Good morning, everyone, and we will start. Give an extra few minutes for people coming. There's another very interesting event happening at UN Foundation, so we wanted to give the chance also those on the way. My name is Fernando Marani. I'm the Program Director of Justice, Institution, and Equality at Pathfinders at the Center of International Cooperation of NYU. And we really want to welcome everyone here in person and all of us, all of you that are following us online. Before getting into the event, just a very quick practical note. There is AI interpretation available here in your phones and your laptops. There is some QR codes on the tables, but also there's a link on the chat where people can follow in several other languages. We would like to start first. Thank you to the Baha'i International Community for hosting us today, but also the co-sponsor of this event, the Oxford Institute of Technology and Justice, and the permanent missions of Costa Rica and Denmark for making this event possible. We are meeting at a moment where AI governance is really moving fast. Just yesterday, the UN announced the International Scientific Panel on AI, and in July this summer, we will have the first global dialogue on AI governance. But here is the simple question that we want to put on the table today. Where does justice and the justice system fit into all of this? From our perspective, I think there are two sides to that story. The first one is justice for AI. Rules and principles are important, but in the end, AI governance will live or die in courts, tribunals, and the broader legal system. It will be the judges, the legal aid providers, lawyers, the court staff, and the community justice in general who will have to make this rule real. They will be responsible for enforcement of the rights that come with those frameworks. Therefore, if access to justice isn't part of the design of AI governance, it will stay on paper and never really improve people's life. The second side of this is AI for justice. And this is based on our discussions in the last few months with different partners working on the justice sector. We can see that there's a lot of excitement and a lot of smart work being done on how AI could really help to improve justice systems to work better. But without clear direction, there's a lot of real risk. If we embed the existing problems that we have in our new technologies instead of fixing them, we are just making systems faster, but not fairer. Used well, AI could really expand access to justice. Used badly, it could just make justice gap even wider. And the justice gap is really already enormous. More than 5 billion people still lack meaningful access to justice around the world. That's why the Justice Action Coalition exists, to push for justice systems that actually work for people, not just for institutions. For the members of the Justice Action Coalition, the guiding principle is people-centered justice. Start from the people's real problems and needs, taking into account the real experiences, and provide impactful, innovative, cost-effective justice solutions. In the age of AI, this matters even more. If we get this right, better justice system can shape better AI governance, and better AI can help deliver better justice. If we get it wrong, we risk doing real harm at scale. So today is about having an honest, practical conversation about both sides of that question: the role of the justice in AI governance and the role of AI in justice systems. We hope that this is just the start of a wider exchange across communities that don't always talk to each other, but really need to. For those joining online, feel free to drop your questions in the chat as we go. We will be picking up them later on the QA section of the panels. And with that, let me turn immediately to our first panel that's going to be moderated by our colleague Nate Edwards, Program Officer at CIC. Thanks, Dr.
Thanks, Fernando, and thanks everyone for being here today. We're really excited for this event. We have a great lineup of panelists. Our first panel is going to focus on the ways in which the justice sector, and in particular people-centered justice, can support more inclusive, equitable, and enforceable AI governance. Stacey Cram, who's online, is a fellow at the Center on International Cooperation. Her, alongside myself, have been researching the role of the justice sector in implementing AI governance. And our research is going to come out next month, but I wanted to share a few reflections from that study to kind of start off this panel. So the first thing that we observe is that the focus of AI governance is really shifting. Principles and values are important, but people are ready to talk about the underlying infrastructure that holds real implications for inclusion and equality and human rights and enforcement. Things like the digital divide, sovereign AI, procurement, data governance, multi-stakeholder inclusion, capacity, trust, transparency. All of these things together are about implementation of AI governance. And as AI governance is implemented, whether countries lean towards a risk-based regulatory framework or defer responsible AI development and deployment to the private sector, or if they sit somewhere in between, the justice sectors ultimately will be called on to respond by enforcing regulations, providing remedy and redress and accountability, even when AI harms take place and regulations are not in existence. So the justice sector is really where policy design and policy impact come together. Given this, justice actors will see the gaps in policy design that hold real implication for people's lives, and they'll also act as an early warning system to understand the types of AI-related harms and rights violations before other people see them. So we think that we should be learning from the justice sector to inform upstream AI governance design. But today's governance conversations don't often do this. Ultimately, effective and inclusive AI governance can only be realized when it is designed with people's experiences in mind and when everyone has equal access to its enforcement. This means designing systems to create independent, trusted, accessible pathways to challenge AI harms, provide transparency and accountability, and offer pathways to remedy and redress. So we see a role for people-centered justice to fill this gap because it frames AI governance as an outcome-oriented implementation challenge. And this approach can inform data governance and transparency, accountable procurement practices, independent oversight that answers to people's needs, and the provision of rights and remedies through accessible pathways. It enables governance that is relevant even as technology continues to shift and change. And it also has value across the public and private sectors. AI governance that's informed by people-centered justice provides private digital companies with a risk mitigation strategy and one that frees up internal resources for innovation. It also creates consumer trust that can lead to product adoption, and it strengthens market predictability and investments and supports fair competition. So at this point, when AI governance priorities are being set with a scientific panel being announced just yesterday, we believe it's important that justice actors be part of this conversation. And so I want to turn it over to this first panel. We're going to talk about a number of different things, how justice fits into global AI governance, how it connects to human rights, where the private sector might engage with this conversation, and also what the people-centered justice approach means for missions here in New York. So I want to start with Anush Rima Tanavosian, who's a senior associate at the Future Society. And the Future Society is an independent nonprofit organization based in the US and Europe focused on AI governance. She previously worked for 10 years in the UN system, including roles in the high-level panel on digital cooperation, UNDP, and UN Global Pulse. So the Future Society has been involved in AI governance for a number of years, including hosting the annual Athens Roundtable on AI and rule of law. And I was wondering if you can draw on this experience to tell us a little bit about how AI governance conversations have evolved, where the justice sector has fit in, and where you see opportunities for that to continue. Thanks.
Thank you. Can everyone hear me? Is it okay? Good morning. Thank you for having me. It's daunting to be the first speaker, but I'll do my best and try to lay a table for us to discuss around. Yes, thank you for the introduction. The Future Society is a nonprofit organization that is devoted for 10 years since its founding on AI governance and policy. So in the lifespan of AI governance, it's actually quite old in that timeline. I recently joined, but I'm very pleased to be working now with a group of colleagues who are following AI governance and policy 24 hours a day for many years, and from our base, which is a team all over the world. The other thing that this organization has to bear on this conversation is that for the past 7 years, we've hosted an annual, essentially a global dialogue, a multi-stakeholder global dialogue on AI governance. It is called the Athens Roundtable on AI and the Rule of Law. It's been hosted for the past 7 years, and the last edition was just in London, and we'll be publishing the findings just today. But by its name, you can see that it started 7 years ago very deeply with participation from people in the judicial community. It really did start out of 7 years ago, thinking about the emerging challenges of AI in the two themes of today's conversation: AI for justice, in fact. How will this affect how judges, lawyers, courts operate, but also how are the laws that govern AI being shaped? And so in the first few editions of the Athens Roundtable, there were many lawyers, human rights advocates, judges participating. UNESCO was one of our core partners. And then I think the conversation has evolved. And so when you look maybe around 6 or so, 5 years ago, as you pointed out, you did get conversations more about the ethics frameworks, the high-level principles of AI governance, and so we were part of those conversations as well. And then also when you look at the global governance conversation, you get into AI safety. The summit series started with the UK hosting the Bletchley Park Summit, which was focused on AI safety. And so these evolutions every year also dictated who was around our table. But we did see less participation, I think, of some of the more core actors of the judicial community. But now I would say is the time to come back to the table, because I would say around, even the landscape has changed in the last 2 years with now actual laws on the books in certain jurisdictions. The EU AI Act in New York, the RAISE Act in California, SB 53, including one that I just recently heard about. There's a California law that says that AI cannot be held accountable if your AI harms someone else. So that's already on the books. I just learned that yesterday. But how does that get interpreted? What does that mean in a world where today you can deploy an AI agent that acts on your behalf? And people are experimenting with it live right now with some of the tools that are out there. And so I think it is incumbent on the legal community to come back to the table, because we need your expertise. A lot of AI governance will come down to how the policies are shaped, but also how they are implemented. Another takeaway from our recent Athens Roundtable, as I mentioned, which was held in London, was Lord Clement Jones from the UK House of Lords made a great intervention about how we have several years now of frameworks that are more like voluntary contributions, voluntary governance, but everyday people are starting to feel the anxiety of the fragmented landscape and who really is accountable and where is their redress. And so I think just to summarize there, we're in a new phase. The governance community, the judicial community should have very much a role to play and a voice at the table, both in the shaping of policies, but also how they get implemented, because that's eventually how everyday people will interpret it and also feel more safe when using these new AI tools. Lastly, I will say that our organization, the Future Society, is looking at the global level on a few concepts like defining red lines or limits. So if it's difficult for the global community to define what AI should do, because it's so new and it's so complex, could we not at least come to some consensus around the unacceptable harms? And so how would you then govern something that's more like a boundary or a limit? It's not saying, again, implementation gets complex, and I think we need people with experience in regulatory frameworks and implementation of laws to be part of these conversations, because otherwise they stay abstract.
Thanks, Anush. Really appreciate that starting place to also understand where the justice sector was maybe more involved at the start of this process about 7 years ago, and how now we're kind of coming back full circle to where that needs to happen again. And I'm curious to dig a little bit more into that maybe during the Q&A. I want to jump to our next speaker because we have a pretty full lineup of speakers today, which is going to be Kate Fox-Principi. She's the lead on the administration of justice at the UN Office of the High Commissioner for Human Rights. She's an Irish qualified lawyer and an expert in international human rights law, and she's been working in different capacities in the Office of the High Commissioner for Human Rights for the last 25 years, including as secretary to the Human Rights Committee. She's currently working in the rule of law section of OHCHR, leading on the administration of justice with a focus on digital technologies, AI, and human rights in the administration of justice. And so Kate is online. Oh, there she is. Okay, great. Can you help connect this discussion with the human rights approach for us here in the room and online, and talk about the role that the justice sector has when it comes to protecting and upholding human rights in the context of AI innovation and its governance?
Thank you, Nate. Thank you very much. Thank you for this invitation. Very interesting discussion on subjects I've been working on for the last year or two in the office. And I'm delighted, of course, to answer your question on the human rights aspects of AI governance in the justice sector. At the outset, I should say that in his report of 2024, the Secretary General called for regulation of the use of AI in the administration of justice to comply with international human rights law. So it's very important thus that we apply a human rights framework when we're talking about AI governance. And human rights law is a vast body of jurisprudence that has developed over 50 years. It's constantly evolving and interpreting all human rights including those rights that are implicated in the administration of justice, such as the right to liberty and security, to a fair trial by an independent jury or judiciary, access to legal remedy, non-discrimination, and privacy. So as to the role of the judicial system in protecting human rights, I see two main roles in AI governance for the judiciary. The first, and this has already been mentioned, is the assessment of the compliance of AI systems with national and international law. And the second relates to the courts and the judiciary's own use of AI and the requirement that the judiciary be accountable when using such AI systems itself. So as to the first role, as guardians of human rights, courts can ensure that the state does not violate human rights through the use of AI systems. And you've already mentioned that domestic courts have been confronted with this issue on many occasions in the last few years. One national court, for example, decided that the failure to release the underlying data behind an algorithm constitutes a violation of due process rights. And another court decided that the use of algorithms embedded with AI resulted in violations of the right to non-discrimination. And these, of course, are all human rights. So both the Committee on the Elimination of Racial Discrimination, which is the committee, the monitoring body of the Convention on the Elimination of Racial Discrimination, and the Special Rapporteur Against Racism, that's the UN Special Rapporteur Against Racism, have come to similar conclusions when data sets used to train AI are embedded with bias and discrimination, reflecting our own societal bias. And I think that this is something that we're all very much aware of at this point. As these cases grow, we would encourage national courts to cite international human rights law and draw from human rights standards to assess compliance of such AI systems with national and international human rights law. For example, the Committee on the Rights of the Child have a general comment, which is an interpretive guidance on children's rights in relation to the digital environment. We also see that the judiciary uses AI in its own work and thus has an obligation to ensure that it is not violating human rights when it uses AI systems. And we have seen, and again, this has been mentioned, various ways in which the judiciary has been using AI and continues to use AI. So, for example, AI is used in case file digitalized management systems, which can improve access to justice and create some efficiencies in judicial work. The judiciary uses AI or digital technology embedded with AI as a legal research tool, and it also uses generative AI, for example, in the summary of cases or the analysis of past interpretation or statutes. However, in these kind of cases, when it comes to the analysis of legal cases, we have seen AI's potential to hallucinate. And I'm sure many of you have heard the controversies in several courts around the world that relate to jurisprudence that was supposed to exist, but did not in fact exist and was hallucinated by AI in particular cases. And this is very worrisome. Such errors can waste court time. It can lead to appeals, and if not stopped in time, can impact the right to a fair trial, which is, of course, a human right, equality before the court, a human right, not to mention trust in the system itself. So the judiciary, and this is, I guess, the fourth way in which the judiciary is using AI, is that it's using systems embedded with AI as part of its decision making. And this is where we come into really risky behavior in terms of human rights. So some judiciaries are using risk assessment tools enabled with AI to assist with bail applications, with parole applications, with sentencing decisions, or the prediction of offenders' risk of recidivism. So this is high risk when it comes to human rights. And why is it high risk? Well, one of the challenges, again, as I'm sure we're all aware at this point, is that with AI systems is that they are often unexplainable. So sometimes the rationale behind the recommendation or the prediction of an AI system is unclear. It's a black box. Sometimes the developer doesn't know why the recommendation was made by the system, and sometimes this is due to proprietary software or intellectual property concerns. So if we take, for example, a situation where a judge wants to use AI to make a prediction for the purpose of deciding whether to commit somebody to pretrial detention. So under international human rights law, pretrial detention should be the exception, and it should be based on an individual determination that the circumstances of each case justify such detention. So we're talking about an individual determination. And the questions are, has a judge fulfilled this duty to undergo an individual determination if they use an AI system in their decision making, which is based on past data of others and not the specific individual, where that data may perpetuate discrimination against a particular group, and when they don't know the basis for AI's recommendation. How can a detainee or their legal representative challenge such a decision if they don't know why the AI system made its prediction? Could deprivation of liberty in these circumstances be arbitrary? And what of the requirement for the judiciary to be independent? These are just some of the issues that the judiciary should be considering when thinking about using AI. And such concerns have caused the Secretary General to recommend that states cease using AI systems in judicial decision-making, such as risk assessments for bail, parole decisions, etc., unless it can be demonstrated that they are in compliance with human rights. Further recommendations from the Secretary General include that the judiciary, of course, be trained in the use of AI and understanding AI, and that the judiciary is involved in the entire life cycle and oversight of AI systems in the justice system. This is for the purpose of ensuring the independence of the judiciary, because there is some concern, for example, for independence of the judiciary, where the executive or the legislative to be responsible for the design of an algorithm that's used in a courtroom, or responsible for the oversight of the technology. Finally, what is often looked when we talk about the use of AI in the judiciary is the issue of judicial discretion, human empathy, and human values. And these are qualities that are essential for any judge, particularly in criminal justice. And we're dealing with some of the most vulnerable human beings within our system. They're in the criminal justice system. So judicial decision makers can use their discretion to recognize the individuality of each case. They look at the human behind the case, and they base decisions on the particular circumstances of a case, rather than a rigid application of law. Human judges make decisions about reasonableness based on a shared understanding of the human experience. And AI systems that leave no room for discretion can lead to rigid and harsh results, and lack the innovation to create or diverge from precedents. So just to wrap up, I would say that I did ask ChatGPT today before I came whether the judiciary should use AI, and the response was as follows. AI can assist judges, but must never replace human judgment, accountability, or due process. And I think that's quite a fair statement. Thank you.
Thank you, Kate. That was great. I think two things from that really stand out to me. One is that talking about the way in which the justice sector helps to localize AI governance also means looking specifically at the way in which AI is being used in the justice sector so that we can ensure it's human rights compliant. And also the need to kind of build on human rights frameworks that already exist to inform AI governance in different types of contexts. And I think our next speaker is going to be able to talk about that even more. Ian Levine is our next speaker. He's worked for the UN, major international human rights organizations, and most recently the human rights policy team at Meta, and is particularly interested in how these different actors can and should intersect to protect and respect human rights in the digital world. So Ian, I want to ask you a little bit about the private sector engagement in this, given your background. It seems that big tech companies are pushing for deregulation of AI governance. Why do you think they're doing this? What are the human rights implications for taking this type of stance? And what can human rights actors contribute to injustice and access to remedy in this ecosystem?
You want me to answer all of that in 5 to 7
5 to
minutes?
7 minutes, that would be great.
Easy. Thanks, everyone. It's great to be here. Great, a hugely relevant topic. I've been around the human rights world for over 40 years now, and I'm increasingly convinced that protecting human rights in the digital world is perhaps the existential challenge for the movement today. On the one hand, we're seeing this extraordinarily rapid development of the digital technologies and AI and their influence on human rights. In many ways, those influences can and are positive. Billions of people around the world are exercising their rights to freedom of expression, participation in political processes, access to information, health, education, right to an adequate standard of living. And at their best, AI technologies, digital technologies more broadly, can strengthen people's abilities to exercise their rights. But as everyone in this room and everyone on the call knows, the harms, the potential harms, the actual harms are also dramatic. Bias and discrimination, surveillance, hate speech, misinformation, disinformation, sexualization of children, incitement to violence, and more. Meta, the company I used to work for, has 4 billion monthly users. So when we think about the influence of tech companies, the numbers of people who they influence in terms of exercising rights and seeing rights put at risk and harmed are way bigger than any individual governments around the world, even the largest companies in the world. Just 2 weeks ago, the head of Anthropic, one of the most important AI companies, said humanity is about to be handed almost unimaginable power, and it is deeply unclear whether our social, political, and technological systems possess the maturity to wield it. I would want to note Anthropic does not have a human rights policy, and in a minute I'll come to talk about why that matters. So AI is real, it's now, and it is shaping massive decisions about all of us. And all of that is happening at a time when, and of course we're sitting right next to the UN, so it feels very important to say this, we are seeing a massive retreat from international norms, from human rights, from commitments to multilateralism. The influence of the UN is declining along with its budget. And not only that, but we are seeing a decline in the shared sense of truth, science, facts, objectivity, and values in an increasingly polarized world. So the challenges are enormous, and the global capacity to respond is significantly reduced. As Prime Minister Carney of Canada said in his very well talked about speech in Davos just a couple of weeks ago, we are in the midst of a rupture, not a transition. Isaac Asimov, the science fiction writer, 45 years ago, maybe he anticipated our world. He said, the saddest aspect of life right now is that science gathers knowledge faster than society gathers wisdom. AI brings intelligence. It does not bring wisdom. And it's only the application of the principles of justice and human rights that we will see the ability to ensure, or at least to try to ensure, that AI technologies are ethical, that they promote human good and flourishing, and the harms that they may contribute to are minimized. So, to your question, at the moment we are seeing what we've seen since last January, when the tech companies aligned themselves, some more publicly than others, some more visibly than others, but they align themselves very clearly with the Trump administration and the principles of the MAGA movement, including I believe that content moderation is censorship of conservative voices. We are seeing a pushback against AI regulation, which is seen as being kind of representing anti-woke woke capitalism, which they're against. They're against woke AI. They're against woke capitalism. This means not only have the tech companies pushed for deregulation in the US, but they have encouraged the US government to use its clout and influence to push back against regulatory frameworks in other parts of the world. So we saw last year that the US government imposed tariffs on Brazil because of the work that the Brazilian Supreme Court has done in imposing fines and restrictions on tech companies in Brazil, especially when they banned X for 3 weeks because of its refusal to take down certain content. And even just yesterday, the New York Times reported on a French investigation into Elon Musk's X and its chat box, Grok, and sexualization of children, as well as the Holocaust denial, which illustrated a fundamental divide between European and American leaders about how to regulate AI and social media, or even whether to restrict it at all. Inevitably, the pushback from the tech companies on AI regulation has also extended to their own internal systems and processes to ensure that human rights norms and principles are established in the development of AI systems. And we're seeing increasingly a rhetoric which says that regulation and human rights due diligence are an obstacle to innovation, which is imperative in this existential challenge of who will dominate the AI world. So I would argue that a key challenge for us all who are concerned with this issue, for all of us who consider ourselves in different ways part of the human rights movement and the justice movement, is to make the business and innovation-centric case for human rights due diligence, for rights-respecting regulations, and for the wisdom that justice brings. We have to be able to make the case more effectively that innovation depends on trust, because without trust, products will not be well received. And if there is not trust, that the products won't succeed, and if we don't have the principles of justice and human rights through the UN Guiding Principles in Business and Human Rights and the broader human rights framework, that we will not succeed. And I think this is where the justice and the human rights movements have a hugely important role to play in finding constructive ways of engaging with tech companies to make sure that these principles are to the fore. We have to be able to convince Anthropic, for example, that if its products challenge civilization, the least it can do is to develop a human rights policy and the human rights due diligence, stakeholder engagement that go with it. And if the justice sector, the previous speaker spoke very well, and I won't repeat anything that she said about the importance of the contribution the justice sector can make, but I think one very critical question which I would just flag is, if justice is to ensure accountability of AI systems, one of the most crucial contributions it can make is to reinforce the clear principle that humans remain responsible for AI-supported decisions. Humans are responsible for the development of AI systems, and ultimately humans will have to account for a lot more to say, but I'm going to stop there. Thank you so much.
Thank you so much, Ian. Really appreciate that intervention. And I love this quote that science gathers knowledge faster than society gathers wisdom, but really appreciate you and the other panelists who are contributing your own wisdom to society around these things from your experience. And I think that the ways in which we engage the private sector are so important here, and align that with human rights. The point you made that the number of people who are being impacted by AI-related harms are being impacted in private context, in this context of dealing with private companies. And so that's where we need to kind of bridge this gap in conversation. So I want to move on to our last but not least speaker of this first panel. We have Alfredo Pizzaro, who's the Minister Counselor from the Permanent Mission of Costa Rica. And I wonder if you can kind of bring this conversation back to the context here in New York around the UN and the global dialogue and the upcoming global dialogue on AI, and also from your own experience with the Costa Rican context. And as a member of the Justice Action Coalition, as well as a facilitator of the UN resolution on the global dialogue for AI governance and the International Independent Scientific Panel on AI, where do you see justice fitting into this conversation? I guess that's really the question I want to ask you. And how do you see people-centered justice in particular supporting member state priorities in relation to these AI governance conversations that are happening here in New York?
Thank you, Nate, and good morning to everyone. Let me begin by thanking Pathfinders for committing the discussion and the Baha'i international community for hosting us today. I also salute my fellow panelists and all participants, joining both in person and online. Costa Rica is honored to be a member of the Justice Action Coalition and to have worked with Spain in the negotiation of the modalities resolution that led to the establishment of the Global Dialogue on AI Governance and the Independent International Scientific Panel on Artificial Intelligence. The composition of the Independent International Scientific Panel was announced yesterday, as Fernando mentioned, and as member states work together to establish the priorities of the first global dialogue ahead of its first session in July in Geneva, justice must occupy a foundational position in both platforms. I'll make 3 points about where justice fits and how people-centered justice should support member state priorities. First, justice as the legitimacy problem that dialogue cannot avoid. The global dialogue on AI governance will convene in July, as I mentioned. But notice what it's called. It's called a dialogue, not a treaty, not a convention. It's a dialogue. AI governance hasn't happened yet. That's precisely why this moment matters. Right now, no one can answer the most basic questions about who decides how AI develops, on what authority. Is it companies building the technology? Is it the states regulating it? Some hybrid arrangement we cannot foresee at this point? The answer remains fundamentally unclear. When 193 states reach consensus, we often mistake that procedural achievement for legitimacy, but it's not necessarily. Institutional agreement rings hollow when billions of people experience governance as remote, technocratic, and unresponsive to their actual lives. This is where people-centered justice becomes essential. Justice provides a theory of legitimate authority rooted in human experience rather than institutional convenience. It answers the question of authority not through procedural formality, but through responsiveness to people's actual needs and their meaningful participation in decisions that affect them. Justice thinking inverts the power dynamic. It begins by asking what problems people face, not what rules institutions prefer to write. It treats those affected by decisions as participants in shaping solutions, not subjects to be regulated. Without this foundational logic, whatever frameworks emerge from the dialogue or any other dialogue become another exercise in governing for people rather than with the people. The global dialogue doesn't need to include justice as one issue among others. It needs justice thinking, which is different, to establish why any AI governance framework deserves to be legitimate at all. I'd like now to talk as my second point on women as the nexus between justice failures and AI governance failures. Costa Rica chairs the 70th session of the Commission on the Status of Women. Both processes, CSW 70 and the AI governance dialogue, confront the same fundamental problem through different lenses. Women face systematic barriers to justice everywhere, whether discriminatory laws, inaccessible legal systems, or the structural inequalities that keeps courts out of reach. As the Secretary General's latest report confirms, women face greater barriers to justice than men in most countries globally, despite decades of reform. These are power imbalances embedded in how decisions get made about women's lives. AI amplifies these patterns. Algorithms trained on biased data replicate discrimination in hiring, credit, healthcare, and criminal justice. Automated systems make determinations about women's lives without transparency or remedy. Digital surveillance enables new forms of gender-based control. What connects these failures? Both justice systems and AI systems make consequential decisions at the scale about people's lives. Both struggle with identical challenges around bias, opacity, accountability, and the distance between decision makers and those affected. When justice fails women, it reinforces inequality, perpetuates violence with impunity, and erodes trust in institutions meant to protect. AI governance that ignores how technology replicates these justice failures abandons half of humanity. Women serve as the test case, revealing whether the global dialogue, an independent international scientific panel on AI, will address how power actually operates, or if it will merely manage technology on behalf of those who already hold it. My last point is about justice as the continuity across technological rupture, which is a word that has already been mentioned. The independent international scientific panel on AI must examine harms that haven't fully materialized from technologies still emerging. The scientific panel will provide the evidence base for understanding AI's impacts, risks, and patterns of harm. The panel can draw on an existing epistemology, because justice often proven methods for understanding how consequential automated decisions affect people's lives, particularly those already marginalized. Take, for instance, the Geneva Conventions that were written for autonomous weapons, yet the principles translate also to this technology. Human rights law wasn't designed for algorithmic discrimination, yet it applies as well. Thus, justice provides normative continuity across technological rupture. The scientific panel can draw on decades of justice sector experience, examining bias in consequential decisions, opacity in institutional processes, and barriers to accountability. In sum, we must ask ourselves to honor existing commitments, SDG 16.3, on equal access to justice, universal human rights, within the AI context. People-centered justice provides a way for both the scientific panel and the global dialogue to maintain moral and legal coherence as technology continues to transform power relationships. Thank you.
Thank you, Alfredo. I think you had so many rich points there and kind of really did a nice job of bringing it back to this moment, which is setting the priorities for the global AI dialogue this summer and the ways in which that justice needs to be a feature of that conversation. I think also something you touched on I just want to bring out is the way in which people-centered justice and being able to connect to people's individual experiences also allows us to understand more differentiated experiences of engaging with technology. So with gender-sensitive justice responses to AI-related harms and so on, it gives kind of a different endpoint for that conversation. We have about 10 minutes for audience questions and answers on this panel. There'll be a second panel and then another segment of question and answers that's related to that. But I wanted to kind of open the floor at this point to see if anyone has questions in the room. And I know people have been writing them in online, so we'll come to those questions as well. Yes, please go ahead. And if you can introduce yourself and then.
Morning, everyone. My name is Mohammed Ibrahim. I'm a former judge from Egypt, currently working as Islamic law expert with the Peace Building, Peace Support United Nations Office. I have 3 points to raise, and being a judge, I'll be very pragmatic and practical here. First of all, the legal framework. Legal framework currently does not allow litigants to challenge AI tools used by reasoning of the judge. So that's something most of legislators should add now, since we have using AI now as part of the court process. Secondly, the idea of the judge using the reasoning, his reasoning based on AI, he should disclose that and reveal it, so every litigant could know where he could challenge that using the benefit of doubt. That's very important. Thirdly, as my colleague Kate mentioned, that judges need to be trained. I think it's a prerequisite before any judge could use any tool. He should declare that in his decision. Otherwise, that could be a petition by the litigant that challenged using this AI by non-trained judges. So it's supposed to be revealed in the court as a ceiling or something that will allow people to know. Last but not least, actually, been working 10 years in peacekeeping, actually, in third world country and developing country. When we speak about AI in a country that doesn't have electricity or internet, that's really unfair. So I think it's, again, not burden of governments only, but also private sector to enable judiciary and litigant in these places for having innovative idea, like for example, Starlink for internet in remote areas, but also for using electricity based on solar energy that will allow judges in places like Afghanistan, Sudan, South Sudan, where I work actually, where these basic doesn't exist. So that would also guarantee for us that these communities would also benefit from AI as ultimate level. Thank you very much, and sorry for being talkative lawyer.
Yes,
I want to
thank
take
you. Thank
the
you
floor
so
whenever
much.
stop talking. Thank you.
Thank you for that intervention. I'm going to bring in a couple of questions from online, and also then we'll kind of distribute those to panelists. So we have a question from Vivian Ramon Tavares, who says, given the emerging tension between ex ante regulatory frameworks and ex post judicial review mechanisms in AI governance, how can justice actors effectively balance the need for adaptive, principle-based oversight with the legal certainty required for enforcement? Maybe we'll start with that one. It's a pretty rich question. Does anyone, one of the first speakers, want to take that question? That's fine. Maybe a question we can come back to in the second panel when we get a little bit more in depth about the ways in which AI is being used in justice systems. Does anyone else have questions in the room? Yeah, please.
I was interested in what you were saying about the risks and harms should also be explored by the scientific panel. This may be a place where the judicial community can be part of the shaping both of the, I don't know if the chapters or the sections of what the scientific panel will report on has been predetermined yet. And I really appreciate your comments about how the global dialogues agenda has not yet been shaped and could be using a framework that is anchored in judicial thinking, which I think is a great idea. On the scientific panel, do they have, themes that they will be covering, and can we expect some conversation around risks and harms and redress and accountability in their work?
Yes, well, as we mentioned, the situation right now with the dialogue is that it's something very alive and very flexible. And when it was being negotiated, one of the things that allowed it to be adopted by consensus and to go through was the fact that it was very open. And because many subjects, many topics, as you may imagine, would prove to be controversial. And so that was one political reason, but there was also a technical reason. And the technical reason is that, as we all have discussed this morning, this is a very new technology that we don't really understand where it's going to be in 5 years from now. So if we had like a very strict principles or topics to work on, the risk was that they would be, irrelevant in a few years' time. So I believe that the beauty or the elegance of this structure is that it is something very open that can be developed over the years, and the experts have a lot of autonomy about where they want to go and what they want to start working on. And we are very excited about what's going to happen in July, and I believe that after July, we'll have a clearer idea of where the discussion is going.
Thanks, Alfredo. Kate, I see your hand is up online. Do you want to jump in?
Yes, thank you very much. Just to make the case for human rights again, maybe I wasn't as forceful as I would like to have been when we're talking about regulation, but human rights would be an important framework to include in any regulatory framework, whether it's an international one, and as I've said, the SG is keen on ensuring that its human rights framework is included, but also nationally. Human rights law is really important in the sense that it constrains the power of the state to protect individual needs and interests. And it can provide a means to define the harm that AI should avoid. And somebody mentioned earlier on about harms and how to reduce harms when it comes to the use of AI. And I think that human rights and the application of human rights law is a very clear way of doing so. I mean, we have huge jurisprudence when it comes to what is the right to privacy, which is not an absolute right. So it can be restricted, but in what circumstances can it be restricted in terms of its lawfulness, necessity, proportionality, etc. We also have very clear law when it comes to what a fair trial is, to guarantees, procedural guarantees behind a fair trial, the non-discrimination, and the extent to which all of these rights can be affected by the use of AI. So I think that it's really important in this discussion that we talk about not just human rights in terms of the phrase human rights, but talk about what human rights means in the sense that it means the application of international human rights law, and that means in comparison to ethics, that means that states are obliged to apply human rights law. So it's the obligation that states have when it comes to human rights law that makes it also a useful framework to use when we're talking about AI governance. Ethics is a very useful way to think about regulation and to think about AI, but ethics is a philosophy. They're not norms and standards like human rights. So I really think that it's time to reinforce the human rights framework in all of the conversations we have about human rights. And with respect to the judge that spoke about the disclosure of the use of AI by judges, that of course is an excellent idea. Some countries are doing it already. I would also say that should go for lawyers as well, that any lawyers using AI should declare it. It then brings me to the issue of automation bias, which some judges apparently, and others, all of us, have this idea that technology is better than us and makes better decisions. And this can have some compromising elements when judges are maybe feel that the prediction or the recommendation made by AI is a better one than they would do. So I think it would be very sad if we got to that state. And yes, the inequalities he also mentioned, inequalities between different groups, and also inequalities between different regions when it comes to the use of AI, because of course of the underlying inequalities and differences in internet, etc. So I mean, all of these issues are something that's very much on our radar, as is accountability. But ultimately, when it comes to these issues, if human rights are violated because of the use of AI, the accountability is the state. The state is the one responsible. So if it cannot succeed nationally, there are international mechanisms that you can go to vindicate your rights. Thank you.
Thanks, Kate. We are running out of time for this first panel. So Ian, I want to let you respond to that.
Seconds.
Yeah. Go for it, and then we're going to round up with one more question.
Very quickly, Alfredo, you spoke really well when you talked about international humanitarian law and human rights laws providing normative continuity, I think you said, which I think is absolutely right. And Kate made a very strong and powerful statement about the importance of human rights law, both for international and national governance. Again, 100% agree. I just want to put in one word for the importance of the UN guiding principles on business and human rights. They're often ignored because they're not treated by the law in the way other standards are. But for dialogues with tech companies about the kind of systems they are putting in place to ensure that their technologies are rights respecting, it provides an incredibly important tool. And when we're advocating with them to develop human rights policies and human rights due diligence, putting the standards of UNGPs at the heart alongside these other standards is incredibly important.
Thank you, and I think that's a great point to kind of end this first discussion on, just because we have a whole other panel. I know there were a lot of questions that were written in online. We'll try to address these in the second Q&A segment from the second panel, but I want to leave enough time for that. So with that, I mean, I think this first panel had a number of really important points, but a few of them stand out to me. We talked about how this is really a full circle moment from the justice sector's involvement in AI governance, going back to about 7 years ago with the start of the Athens Roundtable on AI and Rule of Law. We talked about links to human rights law and the use of AI in legal systems, and how the importance of how AI is being used in legal systems will actually have implications and create trust for people in the broader environment and their relationship to AI. We also talked about how this is an existential moment. We actually need to engage with the private sector more clearly and make a case for the private sectors why this is beneficial, why human rights and a justice-focused response is beneficial for innovation. And that the justice sector needs to be part of this bigger conversation, because technocratic and unresponsive governance, as Alfredo talked about, can't engage with people on the ground, but using a people-centered approach, you can start to actually relate those conversations to people's lived experiences, whether those are gender-related issues or other types of issues that affect different populations in different ways. It's an implementation framework for that conversation. And the last piece, which I think is really important that you both flagged, is this idea that human rights and access to justice provide normative continuity across technological rupture. So as technology continues to change, these types of frameworks and these types of discussions can continue to be relevant in those different contexts. With that, we're going to end the first panel and move to the second panel. I want to introduce Lodovica Rapparelli, who's going to moderate our second panel, and she is online. She is with the Oxford Institute of Technology and Justice and is leading a number of their initiatives related to access to justice. So Lodovica, over to you.
Thank you very much, Nate. Thank you. Well, good morning or good afternoon, depending on where you are in the world. It's a real pleasure to welcome you to this panel on AI and justice. And I think that this is a topic that moved very quickly from the margins of legal debate to the very center of it. And we can say that across the world today, AI tools are already being used or tested in other policing, risk assessment, case allocation, legal research, and even like sentencing support. And as the UN Secretary General Guterres said yesterday, AI is moving at the speed of light, which I think is one of like the most important statement I've ever heard about that. In some contexts, AI promises efficiency, consistency, and access to justice, while in other, it raises profound concerns about transparency, accountability, and the right to a fair trial, as we heard also from other speakers earlier. What makes AI in justice systems particularly sensitive is that it operates in a space where power, rights, and human dignity are directly at stake. And so introducing AI into the justice sector forces us to ask very important but hard questions, such as who does AI actually serve in justice systems, or does it expand access to justice, or it risk deepening existing inequalities? And I think it's very important to understand that these questions are not only theoretical. Courts, prosecutors, justice ministries, they are already grappling with these questions in real time. And that is why evidence-based and comparative work is also so important. And at the Oxford Institute of Technology and Justice, we are working on initiatives such as the AI Justice Atlas, which maps the use of AI across justice systems globally, or practical tools like the Fair Trial Advisor, which is a digital agent that helps judges and legal professionals upholding fair trial guarantees in the age of AI. And I would say that all of this helps grounding this debate in reality. So today's second panel brings together perspectives that reflect this complexity. And rather than searching for the easy answers, we want to focus on what good use of AI in justice might look like and how risks can be addressed, how safeguards can be designed, and how, under the right conditions, AI can become a tool that supports fairer and more accessible and hopefully more effective justice systems. And with that, it is my pleasure to introduce our first speaker, Philip McGrath. Philip is a senior governance specialist at the World Bank. Previously, he was the head of public service transformation delivery in the Department of Public Expenditure and Reform for the Government of Ireland, and he worked in Ireland's Department of Justice. Thank you very much for being here today. My question for you is, I understand that the World Bank has been conducting research on use cases of AI in justice systems. What opportunities are you seeing for AI in the delivery of justice, and what impacts are they having? And also, what lessons does your research offer to countries that are at the beginning of, let's say, AI maturity?
Thank you, Lodovica. Thank you, colleagues. It's a pleasure to be here today.
I'm going to quickly respond to Ludovica's question and talk about some of the research that we've done. What I should say is that it's not speculative. It's very much grounded on what is actually happening. I'm not endorsing these use cases. I'm not saying that, you know, all governments should be using AI for this. This is effectively a scan of the art, if you will. And obviously, the work that we do in the World Bank, we try to obviously identify where there may be entry points then for lower middle income countries, you know, to engage with this sort of technology. We have applied the World Bank's Jupiter framework as a lens for this work. So looking at efficiency, access to justice, and quality of justice system. So was trying to safeguard ethics, trust, rights. We have identified 6 broad areas, and the lines of demarcation are a bit blurred between some of them, but we tried to put them into buckets. And what we are seeing across justice systems, and I should say these are really civil justice, we've kept away from the criminal justice area, is the first use case is in addressing inefficiencies in the court and paper-based court administration. So it's the likes of digitization of legacy records, OCR, speech-to-text, transcription of hearings, translation of court materials, metadata tagging, automation of filing, scheduling, document handling, that sort of stuff. Some really, really strong examples that we've seen there. I mean, for example, in India, the e-courts digitization processes, I think it's over 3.5 billion records have been digitized there. And obviously that then creates circumstances for which stronger AI can be brought in. Same again, and what we're seeing a lot of is transcription of proceedings. World Bank project in Tanzania is, and another one in Azerbaijan, some very strong examples. But we're seeing countries moving from pilots into production, so the likes of the Philippines as well. The second use case then is in supporting judges, reducing judicial workloads. Obviously that's to tackle caseloads and to try and reduce the pressure that exists on judges. We're seeing, I suppose, the likes of case classification and similarity detection, triage and routing of cases, and then automation of low discretion drafting, but also support for these mass claims processing, the likes of, for example, in Germany, for air passenger rights, for example, those types of cases. But some very strong examples we're seeing then from Brazil and Argentina in terms of supporting judges. The third use case then is around access to justice for justice seekers, and obviously, I mean, it was spoken about the 5 billion people who don't have access to justice. So what we are seeing is AI-supported legal information tools, guided procedural pathways, retrieval-based Q&As, human-in-the-loop assistance models. So everything from sort of a hybrid model where you see in the UK is CADI on its citizens' advice, you know, where it's sort of half done by the AI and then half done by a person. Practical guide to justice in Portugal. Alaska at the moment is about to launch its own sort of chatbot for its court systems. So they're the sort of, you know, ways that citizens can engage. But I think we have to recognize the fact that citizens are using ChatGPT or Grok or whatever it is themselves anyway. You know, so do you bother doing this yourselves, or do you wait until the products in the private sector are pretty much, you know, perfected? Privacy and data protection, publishing judgments. So moving away from kind of manual anonymization of judgments to automated anonymization and redaction, name entity recognition, structured publication pipelines. Some really good examples there from Triberto in Italy, but also in Argentina, again, another hybrid model, you know, where it's sort of mostly done by the AI with sort of some suggested, you know, does this need to be redacted type of thing. Obviously that increases open data and open justice. Again, loads of caveats around all of this stuff. Fifth use case then is in the area of augmenting the use of ADR and online dispute resolution.
And we're seeing, obviously, that there are many of the sort of digital first dispute resolution platforms out there, but now with AI coming in, that can help through sort of algorithmic negotiation, it's called, and the generation of settlement options for parties based on their inputs, and some sort of guided mediation pathways, and then obviously escalation to humans where required. Some strong examples here from Canada, Singapore, and Australia, sort of a model for couples that are separating, much cheaper and quicker model to come up with an agreement based on what the parties have said. Sixth and final use case then is in the area of advanced data analytics and AI for judicial effectiveness and reform. This is kind of system level AI, so where analytics, dashboards, adjournments, and delay pattern analysis, that sort of predictive modeling for caseloads and delays, forecasting storages, all of that sort of stuff. We've seen some good examples, for example, from Kenya, predicting adjournment patterns so that interventions can be made, but also India, machine learning models predicting delays across the subordinate courts, and in France then the Court of Cassation AI to identify divergences in jurisprudence. So that's I tried to keep it very quick. That's some of the stuff we're seeing, and we should be publishing fairly soon. So some of the lessons, and this not only from the justice work we've done, we've also done emerging practices across the public sector. I suppose one of the big pieces here is shadow AI. So people are using this anyway, right? So and if you, in managing your government, in managing your judiciary, are not doing something about this, whether it's establishing your multidisciplinary expert group, setting out your guidelines, if you're doing nothing, that is a governance failure in itself. Okay, so all knowledge workers are using AI, whether we like it or not. So something has to be done at a national level, and I think perfection is the enemy of the good here. So if you do nothing waiting for perfection, there's probably a lot of harm that's going to happen in the meantime. So that's sort of my key message, that and get the data right, the data readiness and the architecture. So I hope that gives you a brief overview, and as I say, we hope to have something published fairly soon. This.
Well, thank you very much, Philip, for this rich overview. And I would say that what really stands out is how these use cases show AI not as a single solution, but more like as a set of tools responding to very different justice needs. So you talked about digitalization, translation, easing judicial workload, expanding access to justice. And I would say that your examples from all around the world, like from India, Tanzania to Latin America and Germany, they also underline a very important lesson for countries at early stages of AI maturity. And probably my take-home message is that starting with clear problems like efficiency, access to justice, effectiveness, while embedding safeguards and ethical frameworks is what makes adoption credible and sustainable. On these notes, I will go to the second panelist, Marianne Barbieri. She's a policy analyst at the OECD Directorate for Public Governance, where she leads work on digital transformation for access to justice. Her work focuses on how data, automation, and emerging technologies can strengthen justice systems, improve service delivery, and promote people-centered justice. Welcome, Marianne. Thank you very much. So my question for you would be, I understand that you were one of the authors, of the OECD 2025 report on governing with artificial intelligence, which included a chapter on how AI in justice administration and access to justice. Can you tell us about the trends you are seeing when it comes to the use of AI in justice systems, and what kinds of opportunities and risks do you foresee? Thank you very much.
Thank you very much, Ludovic. I hope that colleagues in the room can hear me well. Hi, everyone online and in the room. I am Marianne, represent the OECD from Paris today. So I will try to keep my presentation within 7 minutes because I received a very good briefing from Nate. And I don't want also to overlap what has been already discussed in the room and also presented by my colleague of panel, Philip McGrath, on the specific use cases. But to complement and to respond your question, Lodovica, the OEC has analyzed as part of the publication Governing with AI over 200 cases on the use of AI across OECD member accession partner countries, including injustice systems. And then from these analyses and also ongoing work with countries that we have at the moment, I can share some trends, some opportunities, and some risks more broadly and more on a systemic level that the OEC team has identified. So in terms of overall trends and not entering too much into details, as this was already presented by my colleague from the World Bank, first point is that the use of AI, what we could observe is that the use of AI, broadly saying now in public sector, has been increasing, but again, still uneven and not yet systemic. In about 2/3 of OECD countries, AI initiatives are either underway, mainly or to streamline internal processes and increase administrative efficiency. A second trend that we have observed with the analysis of these 200 cases is that we see that the use of AI concentrates on certain government functions. Justice is one of the key areas, and the reason is somehow obvious when we think that justice systems face chronic case backlogs, have big resource constraints, handle large volumes of heavy routine tasks. And also all these factors combined make the justice sector as a prime candidate for the use of AI. A third trend that we have identified was that many of the use cases are somehow isolated pilots yet, not embedded in a whole of government strategy or governance framework. In terms of overall common use cases of AI, in our study, we have identified that to a large extent, justice systems have been using AI to mainly enhance efficiency of case handling or other time-consuming administrative tasks. A second important common use that is increasing, as shown as an increasing trend, is that justice systems have been using AI also to improve more and more service delivery thinking from the perspective of the user of services. And a third, but yet more limited number of countries, we see the use of AI to help track how judicial outcomes align with broader policy objectives. The details you can consult in our publication on governing with AI. But now I would like to also cover a bit the current challenges that we have identified on the use of AI in justice, and also on the work that we have been doing with countries lately. So the first important challenge is that most AI uses are incremental improvements, if I can say it this way, with kind of important or real risks that we ended up simply automating inefficiencies instead of using digital technologies, data, and emerging technologies such as AI to transform the design and delivery of justice processes and services. A second important challenge that we identified is that there are strategic and governance gaps with many of AI projects being implemented ad hoc and with a lack of overarching strategy mechanisms. So, or even when we think about our discussions here today, a lack of connection with people-centered justice reforms or agenda. This piecemeal approach kind of leads to limiting opportunities to learn from what worked, what didn't work, what could be scaled up, and also how we could use these individual initiatives to actually achieve strategic impact if they were considered as part of a more within a governance perspective. And a third challenge that I wanted actually also to share is about, and this was actually raised in the discussions of the previous panel by one of the judges in the room, on the data and capacity shortcomings. And it's important also to remind ourselves that AI systems are only as effective as the data and the human capacity behind them. So many courts, and this you could also see with our countries that we work with, many courts still struggle with poor data and human capacity behind them, with data quality, with siloed or incomplete case databases, with outdated IT infrastructure, and often justice institutions lack sufficient in-house technical expertise to also use these systems, which is also, to a certain extent, very problematic. These foundational gaps in our studies showed to hamper AI readiness. And to conclude, in terms of way forward and connecting with our discussion here today, linking to the theme of this panel on how to harness AI for justice in a manner that truly delivers justice for all. Justice systems, if I could give my 3 cents on the discussion, first, get the fundamentals right. Successful digital transformation, implementation, the use of or leverage of AI requires investment in the basics, as I just mentioned. So internal capacities, data governance, infrastructure, and skilled workforce. That's the second point that I also wanted to share is the importance of aligning AI with broader people-centered justice reforms. Technology as a means doesn't work, and I think that we all agree here. Technology should be understood here in the context of our discussions, in the context of people-centered justice, is the way to actually reach broader objectives of better justice being delivered to our people. And introducing AI should not be a tech experimented thing, but part of a broader strategy to improve justice outcomes. And behind the projects or the strategies involving the use of or implementation of AI in the justice sector, we should also ask ourselves, do these projects or tools make the system more responsive to the people's needs? How are the implementation of such tools connected with broader initiatives or researches on legal needs and justice problems, and so on? For countries that are still implementing, or still starting to use AI, it would be important to focus on high benefit, low risk applications in order to allow them to early wins be able to actually grasp the benefits of smaller projects before building confidence and capacity. And last but not least, also important to bridge the gap on evidence and evaluation, as we have identified that without solid evidence, as we have at the moment, on the effectiveness of certain projects, it remains difficult actually to justify scaling up pilots or identify best practices that can actually deliver value in practice to a large scale. Back to you, Ludovica.
Thank you very much, Marianne. Well, I would say this was extremely insightful, and I would say that this also very much complements what we just heard, and the mapping of AI use cases across OECD countries makes very clear that justice systems are becoming a focal point for AI adoption, and largely because of all the issues that you just mentioned. But at the same time, I think that it was very interesting, like your emphasis on the pilot heavy and ad hoc nature of many initiatives, because I think that it highlights a key risks, that is AI risks being used to optimize existing processes without rethinking how justice is actually designed and delivered for people. So thank you very much. And I'll now introduce our third speaker, Caterina Saido. She's an adjunct professor at NYU School of Law and the external legal advisor to the UN Special Rapporteur on the Independence of Judges and Lawyers. In her latter role, she supported the rapporteur with the preparation of the latest thematic report, which examined the promises and pitfalls of AI use by judiciaries, and it was presented to the UN General Assembly in October 2025. Thank you very much, Caterina. I have a question for you. So focusing specifically on the judiciary, can you share some of the key lessons from the Special Rapporteur's latest thematic report on the use of AI by the judiciary?
Thank you, Rica, and my gratitude to all the organizers for convening this very important discussion. I think the first lesson from the report is really what we heard directly from judiciaries themselves. So we were fortunate to engage in consultations with judges, prosecutors, lawyers, other experts from around the world, and we also received lots of written submissions for the report from ministries of justice, NGOs, and others. What did we hear? Well, many of the insights have already been outlined by fellow speakers. AI is being used. There are huge national and regional variations in how it is being used, and there are huge national and regional variations in enabling environments, including whether judicial systems are even digitized at all. But despite that variation, judiciaries almost universally, I would say, feel anxious and underprepared to deal with the arrival of AI. And at the same time, they are being confronted by an incredible drive to make use of these technologies. And we really heard a lot of concern from judges, but also echoed by the rapporteur herself, that judiciaries don't have the information or skills that they need to be able to decide whether to adopt AI at all, let alone what kinds of tools are appropriate. One way of making this decision is, of course, to turn to the normative frameworks that we've already heard about this morning, and echoing, of course, my colleague Kate Fox principally about the importance of a human rights framework here. We know that in international law, there is a human right to a fair and public hearing before a competent, independent, and impartial tribunal. And the rapporteur in this most recent report maintains that realization of that right requires access to a human judge. And I think that also echoes what Kate and indeed ChatGPT was telling us earlier, that AI must assist but not replace judges. But what judges, I think, are struggling with is, in practice, what does that mean? So when and how is it actually appropriate for judiciaries to make use of AI to ensure that they're not being replaced? And I think one of the other key lessons from this report is that it's really difficult to distinguish between AI tools that overtake decisions, that are taking over the role of the independent human tribunal, and those that are just offering assistance. There's a real blurring of the boundaries there. Even apparently administrative uses of AI can really have an impact on substantive decisions. So something like if we have a chronology or a summary of evidence that's created by AI, but which leaves out key pieces of evidence or key facts that are then overlooked by the decision maker. If we have an AI tool that rewrites a judgment for clarity, a generative tool, it can actually alter the legal meaning of that judgment. So those are particular problems because of the issues of opacity and automation bias that Kate already outlined so ably. Because even if judges are only supposed to be assisted by those tools, they're supposed to check them themselves. We know that users are really inclined to trust algorithmic outputs, often uncritically, even if those outputs are the result of an opaque process that they don't understand. And in the report, the rapporteur describes this as the myth of verification, that we really have to be very clear-eyed about what we're asking judges and judiciaries to do. If we say to them, okay, you can use these tools to assist, look at what the output says, and then make your own decision. The reality is judges do not necessarily have the time or the knowledge to be able to really interrogate those outputs. And they are also going to be impacted by these automation biases that will make it really difficult, understandably, for them to depart from particular tools. And when I say depart from those tools, I mean even as so far as just the language that's being suggested by a summary or a chronology that's being suggested. You have an overworked judge, they are much more likely to accept that than to look behind it. That doesn't mean that there's not a place for these tools in judicial systems, but where that place is has to be very carefully considered. And of course, one of the ways to inform that decision is by taking a people-centered justice approach, starting from the concerns that individuals and communities seeking justice have, and thinking about where AI might help to provide a solution, rather than thinking about what AI can do and trying to fit it into our existing systems. And it's a really nuanced and context-specific exercise. It has to be tailored to the specific circumstances and the specific regional contexts or national contexts. But generally speaking, I think we can say that AI is most appropriate for tasks that have a right or wrong answer that can easily be checked. And we've heard a lot from Philip about the kinds of use cases like transcription, translation, digitization of documents through optical character recognition, anonymization. These are all reasonably binary tasks where you can still keep the so-called human in the loop, who, if somebody has a problem that they say has gone wrong, a human administrator or judge can very easily check that and say, oh yes, I'm looking at the original document, or I'm listening to the original recording, and that's not correct. At the much less appropriate end of the spectrum is the use of AI to suggest or recommend the outcome of a decision or to predict the outcome of the decision. And it's partly, I think, inappropriate because of the problems of judicial independence, the idea that this is having an improper influence over an independent judge. But I think there's also a much bigger question that all of us looking at AI use in judiciaries need to think about, which is how do you measure a correct decision in a justice system? You'll sometimes hear in testing, this AI tool for predictions of decision-making was correct 60% of the time, was correct 80% of the time. And what that means is that it reached the same kind of decision as a human judge has done in the past. It's following past patterns of aggregate data points, and it's replicating these sort of same approaches. But we know that a lot of judicial decisions are really finely balanced. They could go either way. And we know that there are lots of problems with trust in courts, but when you think about it, it's somewhat remarkable that judges are so regularly asked to take decisions where one party wins, another party loses, and both sides accept that outcome. And I think, Ian, you said earlier, that AI has knowledge and not wisdom. I think this is that point about legitimacy. These methods of decision-making and deliberation that have grown up over centuries and even millennia. And I question whether litigants would be so quick to accept these decisions if they weren't made by a human judge with empathy, who's listened to the evidence, who's clearly taken both sides into account, but they're based on the recommendations of an algorithm, which has made a prediction based on something that's happened in the past in the majority of cases. And I think that question of legitimacy leads to my final observation, which is that one of the ways that judiciaries serve the needs of people is by being seen to uphold the rule of law and hold powerful people to account. And that means that judiciaries that are considering using AI tools need to be really confident that those tools don't result in transferring power either to the state or to private actors, for example, because they lose control of court users' data, or because the systems become vulnerable to vendor lock-ins. And also to uphold judicial independence, judiciaries need to be making their own decisions about whether to use AI and what tools to employ, because they need to be really confident those tools are not being imposed on them by an executive or by any other actor in order to reduce their capacity to check power and reduce their discretion in their cases. And I'll leave it there. Thank you.
Thank you very much, Katerina. This has been extremely interesting. And I think that the fact that you grounded the discussion so clearly in the lived reality of judges themselves has been incredibly informative. And one of the most striking points, I think, is the paradox you described. So a drive to engage with AI, but it's also coupled with a lack of preparedness to assess, select, and critically interrogate these tools. And also your emphasis on the importance of preserving the role of the human judge is critical and is a critical contribution to this discussion, particularly as judiciaries navigate how AI tools can be used responsibly without undermining judicial independence, as you said. And finally, one final point for me is that the concern you raised about subtle forms of influence, from, as you mentioned, suggested language to administrative assistance. I think that really reminds us that even supportive tools can shape outcomes in ways that are quite hard to detect or resist. On these notes, I'll introduce our fourth speaker, Maja Markovic. Maja is Vice President of the American Arbitration Association Institute, where she leads initiatives bringing together technology, academia, courts, and market players to increase accessible pathway to dispute resolution. She is also Executive Director at Justice Technology Association, a nonprofit supporting tech startups building access to justice solutions. Maya, thank you very much for being here. My question for you is, you work closely with a number of entrepreneurs in the legal system. Can you please tell us about the role of small and medium-sized businesses in increasing access to justice through AI innovations, and how, in your opinion, these efforts can be better integrated into mainstream AI for justice policies? Thank you.
Sure, thank you so much for this important discussion and this excellent overview so far of the groundwork and the landscape of current efforts and challenges. I'm excited to share the builder and the user perspective with you all and how important it is to have a community of technologists like this that are supported by thoughtful and inclusive AI policy and participate in launching social impact ventures. So not only governing for the people, as addressed in the first panel, but also building for the people. So what if we lived in a world where products and solutions to navigate legal processes are available and affordable to everybody? Most people don't realize that there are best practices, mission-aligned values, and a real desire from some entrepreneurs to do good in this field. And they are crucially needed to get help directly into the hands of people that need it at the time that they need it. So problems like bankruptcy, eviction, child custody, record expungement, employment discrimination, probate, these impact-driven solutions exist and they fall into the category of the justice tech sector. So I'll breeze over a little bit of context since that's been covered quite a bit. Obviously, billions of people are in need of legal assistance. They navigate legal issues on their own because the market can't sustain the cost of lawyers for issues that don't generate fees. And because publicly funded free legal assistance is underfunded and overwhelmed, it really can only meet a fraction of this need. So entrepreneurs have stepped up by leveraging technology to deliver direct-to-consumer services that are affordable and within reach. It's really important to put this in the context of it's a tool that they can use, and largely that's an AI technology tool at this stage, versus it's the tool or nothing. It's not the tool or a lawyer. For 90, well, I won't put a number on it, but in the United States, it's 92% of people that need legal help cannot get it. So what exactly is justice tech? It's a field of social impact entrepreneurs that are developing technology and leveraging AI to deliver services and products and tools that help people and organizations navigate their legal problems. So we believe that technology and ethical AI can and should be part of that solution. The challenge, of course, is that justice tech has the potential to be a thriving market aligned with public interest values, but our ecosystem is still very young. It needs more infrastructure, investment channels, institutional support, and very importantly, clear regulatory guidelines to sustain these innovation and impact pipelines. So my organization, Justice Tech Association, supports this ecosystem by creating the connective tissue between founders, technologists, researchers, policymakers, and institutions to maintain and grow the value of these tools. We're a nonprofit trade association that advocates for the founders and encourages broader engagement in tech for good across the sectors. So our goal is to build ethically, to mitigate extractive and negative impacts, engage community, co-design solutions that are built for purpose, and empower leadership with direct experience or knowledge of the problems that are being solved, ultimately to truly address these societal harms. At JTA, we've developed the concept of legal inclusion. It broadly refers to ensuring that all individuals, regardless of their background or characteristics, have equal access to and benefit from their legal system. Ensuring that everyone can access legal services, understand their rights, and participate meaningfully in the legal processes. Our vision is modeled, of course, on the concept of financial inclusion as defined by the World Bank, and legal inclusion is intended to help individuals gain access to useful and affordable products and services that meet their legal needs, all delivered in a responsible and sustainable way. It's an enabler for UN Sustainable Development Goals 10 and 16, and we support the tech solutions that seek to advance legal inclusion, technology that reduces disproportionate impact and inequitable access to justice. So legal inclusion is a fundamental part of the rule of law. It helps promote equality, protect human rights, and strengthen democratic governance. And justice tech is the vehicle to deliver in legal inclusion and economic opportunity. So justice tech is how the ecosystem becomes more integrated in the pursuit of justice equity. The tech is the tool, not the goal. Justice tech, it's really important to remember that justice technology represents a unique challenge and opportunity. So the best solutions are built by those with lived experience with the problem they're trying to solve. In this sector, those people are quite often from underrepresented groups. And because they've got lived experience with the problem they're trying to solve, quite often there's a direct connection between that and their position that is farthest from the resources and the network and the money to build that solution. So what kind of guidelines and support do entrepreneurs need to be able to do their job well and fit into this larger puzzle? It really comes down to three key things. Obviously, the access to justice crisis is massive. It needs innovators and builders to create the ethical products that we're all talking about building these frameworks for. In order to avoid creating ineffective tech tools or those that cause harm, we need to bring these builders to the table as stakeholders. Governance needs to take into account that this is a nascent sector, and it should not be too burdensome for one person who is far from the networks of power with a great idea. And lastly, of course, as we all know, the time is right now. We have a narrow window of opportunity to harness the promise of AI for good. Thanks.
Thank you very much. Well, thank you also for bringing this entrepreneurial lens into the conversation. Your point that billions of people are navigating the legal problems entirely on their own really reframes the debate. And I think that it was really powerful to hear that for many justice seekers, the choice is not between AI and a lawyer, but between an accessible technology or not help at all. And I think that your emphasis also on ethical design, on co-creation, highlights how essential it is to better connect this grassroots innovation with mainstream AI for justice policies. So thank you very much for this. I'm now turning to our last speaker. So the speaker is going to present in Portuguese. And I just wanted to remind all the speakers that AI interpretation is available through the link in the chat and by using the QR code in the room if you are in person. So without further ado, I want to introduce Frederico Franco Alvim. Frederico is the head of Coordination Office for Combating Disinformation and the Center for Democratic Culture and Digital Rights of the Federal Supreme Court. He is also the former Special Advisor and former Chief Advisor to the Special Advisory Office for Combating Disinformation of the Superior Electoral Court. And his recent research and publication focus on the use of AI in electoral systems. So welcome, Frederico. Thank you very much. My question for you is, bringing this conversation to the national context and recognizing that Brazil is in an electoral year, can you talk to us about how technology and AI is being used in the context of elections? Also, what are the positive opportunities and potential risks? And finally, what should justice systems be focused on this context? And lastly, I just wanted to remind participants that AI interpretation is available on your smartphone, on your computer, if you go to the link provided or if you scan the QR code in the room. Thank you very much. Thank you, Frederico.
Muchísimas gracias, Ludovica. Yo noto la presencia de muchos hispanohablantes en esta sala, entonces voy a hablar en español para que puedan prescindir de la traducción, ¿no? Bueno, me toca hablar de los nuevos retos de las democracias electorales con la llegada de la inteligencia artificial. Y en estos pocos minutos me gustaría tratar de este tema en básicamente 4 dimensiones. Porque para saber lo que las instituciones pueden hacer con la inteligencia artificial, es necesario anteriormente conocer a un panel de cambios, un panel de amenazas y un panel de desafíos, para que entonces podamos pensar en nuevos usos positivos de la inteligencia artificial desde las instituciones. Bueno, Empezando con este panel de cambios, nosotros somos de una generación, la mayoría de nosotros acá, de una generación que ha crecido con un modelo de comunicación basado en los medios analógicos. Nosotros que somos del tiempo de la radio y de la televisión, estamos acostumbrados a un ecosistema basado en unas pocas fuentes periodísticas y noticiosas que estaban ahí emitiendo sus interpretaciones del mundo basados en una seriedad, una responsabilidad editorial. Pero las cosas empiezan a cambiar cuando llegamos a este nuevo modelo basado en la Internet. En la primera fase de la Internet, damos inicio a un modelo de comunicación que ya no es una comunicación de pocos para todos en un contexto filtrado, sino una comunicación de todos para todos sin ningún control. Pero a partir de los años 2000, cuando la inteligencia artificial pasa a dominar a este espacio digital, tenemos ahí algunos cambios profundos que a lo largo de básicamente 23, 25 años van a surtir una revolución en este ecosistema de fuentes de información. Bueno, para empezar, que hoy tenemos más de que este sistema de una comunicación de todos para todos sin ningún filtrado. Para empezar, tenemos más una comunicación que es, en primer lugar, una comunicación de bots para todos, porque tenemos una gran presencia de agentes automatizados participando de esta esfera pública. En segundo lugar, tenemos un problema relacionado con las interferencias algorítmicas, porque tenemos una nueva configuración de la libertad de expresión, en que muchos de nosotros tenemos la oportunidad de hablar, sin necesariamente la oportunidad de sermos oídos. Los algoritmos determinan lo que se recibe y lo que se ve efectivamente en sus territorios digitales. En tercer lugar, tenemos un problema relacionado con esta superexploración o mineración de datos para fines de una comunicación personalizada, porque dentro de esta configuración tenemos incluso una posibilidad de una comunicación que ya no es una comunicación de uno para todos, sino una comunicación de uno para usted. Los productores de desinformación en esta nueva clave de la comunicación tienen, por lo tanto, la oportunidad de comunicar y producir a sus mentiras emocionales basadas en las fragilidades de nuestras mentes, a los disparadores mentales y otras cosas que hacen con que estas comunicaciones nocivas tengan un grado de eficacia muy alto, ¿no? Y por fin tenemos, nosotros igual somos acostumbrados a un tiempo en que encuadráramos las imágenes, los audios, los videos como pruebas de la realidad. Sin embargo, con la ascensión de la inteligencia artificial generativa, estas mentiras y desinformaciones hoy salen con sus pruebas digitales de imágenes estáticos o dinámicos que hacen con que se pueda mentir con un grado de probabilidad de conversión extremadamente grande. Bueno, y entonces llegamos a un nuevo panel de amenazas a las democracias e instituciones electorales, que empieza con la reducción de la fricción en la producción de la mala información. En primer lugar, porque la inteligencia artificial permite una reducción de costos en todos los sentidos. Se vuelve más rápido, menos dispendioso y menos necesario desde un punto de vista del uso de la imaginación o de la creatividad para desarrollar estos discursos de polarización y distorsión de la realidad. En segundo lugar, por la propia configuración de la Internet, con la ayuda de la inteligencia artificial, una reducción de los riesgos, porque estamos hablando de una comunicación basada en principios de anonimato, con la posibilidad de una comunicación transfronteriza, o sea, fuera de la capacidad punitiva de los estados nacionales, y igual una comunicación que por primera vez en la historia de la humanidad genera una clave de comunicación masiva invisible, porque a través de herramientas de las redes sociales como dark ads o dark posts, se torna posible comunicar para mucha gente totalmente afuera o abajo de los radares de las instituciones. Y, por fin, un dilema relacionado con la multiplicación de los atacantes, porque ahora tenemos una clave de campañas electorales participatorias en la que las personas no son más puras receptoras de comunicación política, sino productoras, están ahí en las redes peleando, están ahí en las redes en estas guerras culturales, y por lo tanto salimos igual de una clave en que la mala información o la información ilícita desde el punto de vista de las reglas electorales ya no es una comunicación top-down, né, que tiene su origen en pocos actores, sino una comunicación bottom-up, porque la militancia digital está ahí transgrediendo a las leyes electorales a todos los momentos. Bueno, sale de ahí un nuevo paquete muy ancho de nuevas patologías electorales, porque no se trata solamente de estas prácticas de infoxicación y de distorsión de la realidad. En verdad, la inteligencia artificial está para todos los tipos de comunicación nociva y que envuelve incluso adentro de operaciones de influencia, prácticas de desestabilización, de polarización, de incitación al conflicto, prácticas de acoso, discriminación, violencia política, chantajes psicométricos y así por adelante. Entonces, nosotros tenemos hoy una reconfiguración, y este es mi tercer punto, de un panel de retos de las instituciones electorales. Porque las instituciones electorales tradicionalmente tendrían una misión que es compleja, no es sencilla, que era la misión de producir integridad electoral. Esto sigue necesario, pero es insuficiente, porque la desinformación logra desplegar la naturaleza verdadera o la calidad del trabajo de las instituciones, se separa de la percepción social de estos trabajos. Y por lo tanto, más do que garantizar integridad electoral, nosotros hoy debemos de garantizar o producir percepción de integridad electoral en marcos de una comunicación estratégica para generación de confianza, para defensa reputacional, en los cuales la inteligencia artificial puede jugar un papel muy positivo sin ninguna duda. Pero tenemos adentro de un escenario en que las mentiras emotivas toman las riendas, tenemos igual que garantizar o volver a la normalidad de las elecciones, porque lo que tenemos hoy en términos globales es que los estados nacionales perdiendo la capacidad de mantener las elecciones dentro de su clave regular de juegos sustitutivos del conflicto. Bueno, claro, tenemos mucho que hablar de estos aspectos negativos, pero igual tenemos que hablar de un panel felizmente ancho igual, de oportunidades. La inteligencia artificial a favor de la democracia básicamente se puede pensar en tres distintos vectores. Podemos pensar en el uso de la inteligencia artificial para optimizar las campañas políticas, generando igualdad, generando inclusión, etcétera, etcétera. Podemos pensar en la inteligencia artificial para fortalecer a la ciudadanía y a la sociedad civil, o sea, reforzar estos sistemas de vigilancia social, incluso en el campo del área de las misiones de observación electoral, y por fin, claro, adentro de estas actividades para fortalecer los propios organismos electorales, pasando por eliminar la falsa percepción de que la inteligencia artificial juega solamente un papel negativo. Por lo contrario, no podemos dispensar o prescindir de la inteligencia artificial para combatir a los males traídos por la propia inteligencia artificial. Alrededor del mundo tenemos hoy docenas de experiencias institucionales muy positivas que incluso les invito a leer si acaso tengan interés. Nuestro informe de la Red Mundial de Justicia Electoral tenemos en inglés, tenemos disponible igual en español sobre la regulación de la inteligencia artificial en este área electoral, pero básicamente tenemos que invertir cada vez más nuestras energías para aprovechar de lo bueno que se puede hacer con estas tecnologías, por ejemplo, para la detección o monitoreo automático de mensajes de violencia política de género, de desinformación, para la detección de ultrafalsidades. No podemos prescindir de la pericia digital, por ejemplo, para hacer o deshacer los deepfakes, los deep nudes y otros mensajes que tumultúan la integridad de las elecciones hoy. Muchísimas gracias.
Thank you, Frederico. Okay, so I'm also conscious of the time, so I think that I will just wrap up this session and leave the floor to Nate to ask like some Q&A if there's some time. So in today's discussion, we heard that AI is already being used in justice systems in practical ways, offering real potential to improve efficiency, expand access to justice, and support the functioning of courts. But at the same time, many initiatives remain fragmented or experimental, and this raises concerns about governance, coherence, long-term impact. And I would say that really interesting it was that the discussion also underscored the importance of clear normative frameworks to safeguard judicial independence, fundamental rights, fair trial, public trust. And overall, my take-home message was that the shared challenge is ensuring that AI strengthens justice systems while keeping people rights and accountability center. So with that, I would like to thank all of our speakers for their thoughtful contributions, and now we'll give the floor back to Nate for the Q&A session.
Thank you, Ludovica, and thank you to our speakers for their contributions. We have just a few minutes left. I do want to address a couple of questions that have come in. So I wanted to pass the floor first to UNDP, who I think is online. Lara Dermai, if you can hear us, the floor is yours for your question.
Thank you. Thank you very much, Nate. So my name is Lara Dermai. I work as a justice specialist in the rule of law, justice and security team of UNDP based in New York. Apologies, it was my plan to be with you in person today, but I'm a little bit under the weather, so apologies for my voice. Thank you for organizing this critical conversation and giving me the opportunity to share a few reflections. So as UNDP, we provide technical support to national and justice and security reform processes and efforts to advance access to justice in developing settings. And that includes more and more often the use of new technologies, including AI. So it's not a new trend, but it really kicked off in 2021, and we realized we needed to develop a dedicated work stream with policy guidance tools and internal knowledge management for our rule of law experts in the field who are supporting the courts, the judges to deal with these developments. So what we have seen from this experience is that digitalization is certainly a real opportunity for meaningful transformation of the justice sector, not only in terms of efficiency, but also transparency and increased accessibility. We have a lot of many great examples. We have I want to mention it in the state of Palestine. We support the development of Mizan 2.0, a court and case management system which is incredible and could be a model for other places with interoperability with the civil registry, Ministry of Finance, very, very advanced, and it really has facilitated access to justice for the Palestinian people, especially seeing the restrictions on movement that they face over there. We also have been supporting the Brazil 4.0 that I'm sure with the national court system, and this system allows, among other things, data and information management with AI to sustain evidence-based legal policy making, which is a great example also of how digital and AI use can improve justice outcomes. But we have many other examples. There's this Kenya Small Claims app, etc. But what we see, one of the great risks is that this high appetite for technology and comes with a pressure to engage in fast-paced processes of digitalization. And that increases the risks and also the risks of failure of these processes for many different reasons. It can from lack of leadership of the judiciaries or the lack of proper national digital ecosystems to sustain the newly introduced technologies. And the tendency favors the over-reliance on tech experts and tech companies, and this has been a real issue. I just want to give a quick example. Data security doesn't mean the same thing for a rule of law expert and for an engineer. The engineer is telling you it's secure because he secured the encryption, but he cannot appreciate the sensitivity of the data or decide who can access it. So it's a very important challenge, and that's why our focus has been placed on building the capacities of justice actors to not only understand and engage in these processes, but to own them, emphasizing, like many of you did today, that technology is a tool and not an objective. And when it comes to AI, a lot has already been said. I don't want to repeat. AI, UNDP is very much engaged in these developments for AI for development. We have an AI policy to be released soon. But here again, the pressure is, if you don't use it, you lose. So we have this sense that those who know and master the tools will be miles ahead. And that again brings that pressure. But what I think is clear from the conversation today is that the use of AI in justice brings specific risks and needs dedicated attention. General AI policies and principles are not sufficient to cover those risks, especially in a context where most AI deployments remain ad hoc and undocumented. So we are planning to work on this area, especially knowing that there's also the unregulated and non-transparent use of AI by judges, clerks, and lawyers, or even self-litigants, as was mentioned by others today. And knowing that very few courts have proper governance frameworks as of today. So I don't want to take more time. I know we are closing, but feel free to reach out. We have a lot of tools and experience in this domain and would like to further engage with all of you on these matters. Thank you so much.
Thank you, Lara. And we are coming to the end of our time. I just wanted to quickly go to Dr. Kamel El Hilali, who's online from UNESCO, who I think wanted to come in. If you can maybe keep your comments to about 1 minute, if possible.
Hi, everyone. I hope you can hear me well. Thank you very much for this opportunity to speak very briefly. So I'm Kamel El Hilali. I'm the Doctor of Law, and I'm working as an AI and the rule of law specialist here at UNESCO in Paris. And basically, I will be very brief, but our job is to train judges, prosecutors, court staff around the world on the use of AI, the ethical and human rights risks associated with this technology. And so far we have trained more around 40,000 judicial operators in more than 160 countries. We cover the basics of AI, the tools used in different countries. We provide, of course, explanation regarding the ethical and human rights risks. We help them define their strategies to implement AI and to conduct ethical impact and human rights impact assessments. So far, we also have developed different tools that are available freely online to all member states. And those include a global toolkit on AI and the rule of law for the judiciary, which basically covers all of these questions that can be used freely by judicial training institutions and courts, including also universities. We also recently published the guidelines for the use of AI in courts and tribunals. The idea was very simple. Courts are interested in using AI. They don't know how to process with it. They don't know what should be the principles and how to implement them. So we provided this guidance in the document. And currently we are working with Oxford University, including the team of Lodovica, to develop a new MOOC on AI in the judiciary that will cover important topic, including the intersection of Gen AI and evidence, fair trial, access to justice, and women's rights. So we are fully available to support member states around the world on these questions, and I'm happy to keep in touch. And you can find me on LinkedIn and via the UNESCO website. So happy to keep in touch and respond to any question of participants. Thank you so much.
Thank you. And I want to pass the floor to Fernando to give some closing remarks.
Thank you, Nate, and thank you, everyone. I'm sorry that we are a few minutes late, but I think it was worth it. We did a kind of a 360 round of upstream, downstream, from how the justice sector was engaged initially in the global discussions on AI, how then disappeared, and now how we are trying to get it back. I would just start briefly with what Alfredo says about, there's a lot of noise about global governance on AI, but we are not there yet. So that gave us a window of opportunity that will close very fast. But something that we saw today, then to the work that many of our partners, like the World Bank, OECD, the UN, and HEAL, and many others are doing is the AI is already there in the justice sector. I think that, of course, the use is uneven. There is different, there is still a growing digital gap in regions, in countries, but the potential of AI, as many other technologies, to close that justice gap is huge. I would just take, I think, Katerina said one element that I think is very relevant is yes, it's fine to use AI in the justice sector, but make it a deliberate strategy. I think if we wait to come up with the strategies, we would just leave the justice community alone. I think that they see the opportunity, they are starting to use it. I think it's fast for the governments and the international community to come up with really good guidance, and that brings us to why that's important. Because at the end of the day, the role of the justice sector is key on the relation between individuals and governments on the trust. And I think that if they perceive, if the users, if the individuals, if the people on the ground see that the AI is being used by the justice sector without guidance, without global regulations, the trust will disappear. And the trust is key also to address another tension that we see between sometimes the narrative we hear from the private sector, this idea that regulation goes against innovation. I think that today we saw a lot of good examples how actually good regulation can help innovation, because at the end of the day, address some of those concerns that people will have when using these technologies. Who get to decide? I think that that's another question that Alfredo put on the table early on when we talk about global governance. I think, of course, it's for all of us. We believe in honestly with the real multi-stakeholder discussion. I think the global dialogue on AI, the Athens conference, I think there are great opportunities. And one of the things that was very clear also going back today is we should not forget what we already have. And I think Kate mentioned more than 50 years of development of international human rights law. That's a framework that can help address bias, opacity, and some of the barriers. So I will just wrap up with this idea that we have an opportunity, we have a window for creating a global governance that address some of the risk of AI. If we bring the right people to the table, if we bring the judges, if we bring the judicial sector, and if we bring the international human rights community as well. This is a call for governments, it's a call for the scientific panel to early on in the work to put these issues related to justice, right, and human rights in their framework of work. So I'm really glad. I hope that everyone enjoyed the discussion. I think that there's a lot more that we can unpack. Unfortunately, we don't have more time today. But to conclude, I just also want to thank, of course, Ludovica, our partners, the mission of Costa Rica and Denmark that made this possible, but especially to our team at Pathfinder, especially to Nate Edwards, who has been leading this work. So congratulations for what you achieved. Thank you, everyone, for being here today.